So we have done with habeas corpus, mandamus and prohibition. Just a small revision. Habeas corpus is to bring the body, mandamus is to command, and prohibition is to prohibit. Habeas corpus is issued against an illegal detention. It could be issued for both public and private authority or person. Mandamus is issued only to public authorities. We have seen public offices, judiciary, corporations, such thing which has a statutory entity or a statutory background. And prohibition is a writ which is issued by a superior court to the inferior courts. Even the writ of certiorari is similar. So the literal meaning of the writ certiorari is to be certified, that is to be informed. This writ is also issued by a superior court to the inferior courts. So this writ of certiorari is issued by a court higher in authority to a lower court or tribunal, ordering them either to transfer the case pending or to quash their orders. So we have two important things. ఒక పై స్థాయి కోర్ట్ ఒక కింద స్థాయి కోర్ట్కి ఈ రిట్ ఇష్యూ చేయవచ్చు. సర్టిరరీ అంటే టు బి సర్టిఫైడ్, టు బి ఇన్ఫార్మ్డ్, తెలియజేయాలి, సర్టిఫై చేయాలి, ధృవీకరించడం అంటాము. సో ఒక పై స్థాయి కోర్ట్ కింద స్థాయి కోర్ట్కి ఈ ఇష్యూ రిట్ చేస్తుంది. ఎలాంటి సందర్భంలో? ఆ కింద స్థాయి కోర్టులో ఒకవేళ ఆ జ్యూరిస్డిక్షన్ కానీ ఆ ప్రొసీజర్ కానీ if it is different, then the higher courts or the higher authority can give an order to transfer such case to the higher authority courts. ఆ చిన్న తక్కువలో ఉన్న కోర్ట్ని ఆ కేసెస్ని మాకు ట్రాన్స్ఫర్ చేయమని పై స్థాయి కోర్ట్ అడగవచ్చు. లేదంటే ఆ ఇచ్చిన జడ్జిమెంట్ని క్వాష్ చేయమని కూడా ఆర్డర్ చేయవచ్చు. So these are the two things. One is the higher authority court could order the lower authority court or inferior court to transfer such case and also could issue writ to quash such orders. So basically the writ of certiorari having been implemented in 3 cases when the inferior court has no jurisdiction. ఒకవేళ వాళ్ళ పరిధిలో ఆ కేస్ లేనప్పుడు, దట్ ఈస్ when we have excess of jurisdiction or the court is acting in excess of jurisdiction. ఆ కోర్ట్ పరిధిని దాటి ప్రొసీడింగ్స్ ఒకవేళ తీస్తే, that higher courts can issue a writ saying that to transfer such case to higher authority courts. And we also have lack of jurisdiction. One is excess of jurisdiction. ఆ jurisdiction రాకున్నా jurisdiction దాటి, ఆ jurisdiction పరిధి దాటి ఒకవేళ కేసెస్ తీసుకుంటే అలాంటి కేసెస్ని మాకు ట్రాన్స్ఫర్ చేయండి, అది మీ హద్దులో లేదు, అది మీ jurisdictionలో రాదు అని పై స్థాయి కోర్ట్ ఆర్డర్ ఇవ్వచ్చు. లేదంటే అది మీ jurisdictionకి సంబంధం లేదు అని కూడా ఇవ్వచ్చు. Otherwise, error of law. If the inferior court has done some mistake in giving the judgment or it has not followed the due process of law, అలాంటి సందర్భంలో కూడా చిన్న స్థాయి కోర్టుకి పై స్థాయి కోర్ట్ ఈ రిట్స్ జారీ చేయవచ్చు. 3 important things we need to know. One is excess of jurisdiction, one is lack of jurisdiction, and one is error of law. These are the 3 grounds on which the higher level courts or superior courts could issue the writ of certiorari to inferior courts, saying that you have acted in excess of your jurisdiction, or you do not have the jurisdiction or the limits to take that case, or the inferior courts have done a mistake in interpreting the law. So there is also an error of law. On this basis, the superior court could order the inferior court to transfer the case to the higher courts or superior courts on this three bases: excess of jurisdiction, lack of jurisdiction, and error of law. So we say the writ of certiorari is also between superior courts and inferior courts. Here we also say tribunals. Even these are the quasi-judicial bodies. So here, pre-1991, this writ of certiorari has been issued only for judicial authorities. But after that, we have also added that administrative authorities could also be issued these writs. Only administrative authorities. Here we do not issue these writs to legislative bodies or private individuals. So now the case is the writ of certiorari could also be issued against administrative authorities. So we have an example here regarding the writ of certiorari. When we say this writ is issued by superior court to inferior court for lack of jurisdiction, for excess of jurisdiction, or for error of law, to transfer the case to the superior court or to quash that order. ఒక జడ్జ్ ఏదైనా ఒక పర్సన్కి సన్నిహితుడైతే, రిలేటివ్ అయితే అలాంటి కేసు తీసుకోకూడదు. వాలంటరీగా వీరు నా రిలేటివ్స్, తెలిసిన వాళ్ళు అని వేరే జడ్జ్కి అయినా వేరే కోర్టుకి ట్రాన్స్ఫర్ చేసేయాలి. ఒకవేళ అలాంటి సందర్భంలో చెయ్యకపోతే ద హయ్యర్ కోర్ట్స్ క్యాన్ ఇష్యూ ద రిట్, బికాజ్ యూ కెన్ నాట్ గివ్ అ ఫేవరబుల్ జడ్జ్మెంట్. ఒక ఇంపార్షియల్ జడ్జ్మెంట్ వస్తుందని నమ్మకం ఉండదు. Because the concerned person may be advocate or maybe the person who have committed the crime. Maybe he is the relative of that judge. So in that cases, voluntarily a judge has to give the cases or transfer the cases to other courts. In failure of that, the higher superior courts can issue this writ saying that you transfer the case to the other court. So that is an example, because here we say when lack of jurisdiction or error of law, anything could happen. The judgment may not be impartial. So this is an example of certiorari. Writ of Quo Warranto. Quo Warranto is by what warrant? Warrant means authority. By what authority a person is performing the job? What authority do you have? Any public authority, if he is involved in implementing any action or performing his duty, that is, there need to be have some authority given by the statutory body. So literal meaning of Quo Warranto is by what authority. So we have this writ of Quo Warranto to ensure that a person should not do such work which violates their authority, or should not indulge in some activities which is not under their power. వాళ్ళకి ఉన్న పరిధులు దాటి, వాళ్ళకి ఉన్న పవర్స్ని దాటి ఏదైనా వర్క్ చేస్తే అలాంటి సమయంలో ఇలాంటి రిట్స్ ఇష్యూ అవుతుంది. రిట్స్ ఆఫ్ కో వారెంటో అనేది ఇష్యూ చేయబడుతుంది. సో దిస్ ఈజ్ రిలేటెడ్ టు ద అథారిటీ ఆఫ్ దట్ పర్సన్, ద పవర్ ఆఫ్ దట్ పర్సన్. సో ద కోర్ట్ విల్ ఆస్క్, by what authority you have done this work? So if the action of that public authority invalidates or encroaches the fundamental right of any citizen, that aggrieved citizen can move Supreme Court, and Supreme Court will issue a writ saying that by what authority you have done this work or issued these orders. So Supreme Court or High Court issues this writ to prevent illegal assumption of a power by a public office or public officer. So there is a lot many of examples. You have to know that every public authority has guided by some service rules. They have some jurisdiction, some authority. They cannot indulge in such works which is not given in their service, like they have to be within the limits of the power. If such power is misused, if the power of any officer is misused, then the Supreme Court could issue this writ of quo warranto. We have an example here. For example, if a vice chancellor in a university has the authority to give opportunity or to recruit a person, but if such officer at higher level, that is vice chancellor, recruits any person in the university against the law or against the standards, be it qualification or something else, if he recruits a teaching staff or non-teaching staff against the standards, then the court could issue this writ of quo warranto. That is, the court asks that person, that is vice chancellor here in our example, by what authority you have recruited by not following all the norms. So this writ of quo warranto is a tool within the hands of Supreme Court and High Court to stop that a public officer misuses their power. So the misuse of power is a ground where the superior courts or High Court or Supreme Court could issue writs to particular person. So quo warranto can be issued only when substantive public officer, that is who has a authority, who is a permanent officer. So only the officer who is permanent and who has acted against or over his power is liable to be issued this writ. It can't be issued against private or ministerial office. So here legislative body or ministerial office is, they cannot be issued writs against these offices. So this writ of quo warranto stops a person for illegal usurpation of the power. So all these writs of mandamus, writs of habeas corpus, writs of prohibition, writ of certiorari and writ of quo warranto guarantees a person, guarantees their fundamental right against the encroachment of the state or private body. So when I say writs, it is the basic thing, fundamental thing. Under Article 32, these are the tools with Supreme Court and High Court to protect a person's individual liberty, to protect a person against the detention. So that is the reason why we call this Article 32 as the soul and heart of the Constitution. We also have one more writ, that is writ of injunction, which is actually not mentioned in our Constitution. So both High Court and Supreme Court has authority to issue writs. When I say Supreme Court, it is under Article 32. When I say High Court, it is under Article 226. Just to know this, the scope or the jurisdiction of the Supreme Court is narrower here. The jurisdiction of High Court is larger in issuing this writ. because the Supreme Court could issue writ only to enforce fundamental rights, and the High Court could issue writs not only to enforce fundamental rights, but it can also issue writs to enforce other ordinary or legal rights. That is why I say the scope of Supreme Court is narrow and the scope of High Court is wider. So only fundamental rights can be protected by the Supreme Court, but the High Court can issue writs not only for the fundamental rights but also for the ordinary rights. So territorial jurisdiction. Obviously, Supreme Court's jurisdiction expands to entire territory of India. That is, their judgments are enforceable in all parts of the India. High Court's judgment, that is the ruling, the jurisdiction of the High Court is within that state only. So when we say jurisdiction, obviously Supreme Court jurisdiction is much wider and High Court's jurisdiction is limited only to that state. Article 32. This power of Supreme Court of issuing writs comes under its original jurisdiction. So this article binds the Supreme Court to not refuse any person whose fundamental right has been violated. The Supreme Court is mandated to take that issue and give writs on such cases. So it is mandatory on the part of Supreme Court. So Supreme Court may not refuse to exercise its power to issue writs. And in case of High Court, it has a discretionary power, because High Courts can enforce both fundamental rights and other legal rights. It may or may not entertain such proceedings. Otherwise, we can also say that High Court has a discretionary power to issue writs. The High Court may or may not issue writs, but Supreme Court has to issue these writs because it comes under its original jurisdiction. So this is the gist of Article 32, very important article in fundamental rights. Entire fundamental rights, right from Article 14 to Article 35, rests on the Article 32. That is why Dr. B.R. Ambedkar has said Article 32 is the soul and heart of the Constitution, without which the entire Constitution is a nullity. So we have a meaning to the Constitution because this gives power to any person to approach court in case where their fundamental rights has been violated. So just these 5 writs are important. They have their own importance. They have their own circumstances on which the Supreme Court or High Court could issue writs. Thanks for watching my video.